good afternoon, everyone. My name is Alyssa Chow, and I'm an attorney in the Sacramento area. I am also joined today by our very special guest, Shannon Downs. She is a California licensed professional fiduciary, and if you've attended any of my previous seminars, you probably have heard me talk about how valuable it is to have a private professional fiduciary step in some situations, especially when it relates to your estate planning documents. So today we're going to talk about some tales from a professional fiduciary, where Shannon will go into some detail and we'll talk a little bit about some experiences that she's had and when professional fiduciaries have been necessary in certain cases. But before we get into that, a little bit about me. If you haven't seen any of my previous presentations, I am an estate planning attorney in the Sacramento area. I also grew up in the Pocket Greenhaven area, and I've been involved with ACC for quite a while. All dating back to high school, I was volunteering, and in recent years, I've mostly volunteered at recent events that ACC has put on. So you may have seen me, bussing tables or passing out food at past ACC fundraisers.
Yeah, and I am a fiduciary in Sacramento. My name is Shannon Downs, and I also am from the Pocket area. At one point I went to Kennedy, and so I'm pretty familiar with this area here. So, I kind of know some of the area and people in the area. And yeah, I've been a fiduciary for about 6 years now, and my office is located in Sacramento. And I work a lot with Alyssa, who represents me on a lot of matters.
Okay. So before we get into some of the tales from a professional fiduciary, we did want to go over generally what some of the different documents are that a professional fiduciary might need to be appointed for. And also just generally what the role of a professional fiduciary is.
Yeah, lots of times people get us mixed up when they hear fiduciary. They think, oh, well, we just advise people on money and handle people's finances. And actually, the word fiduciary really means just someone who is given a position of trust and who has a duty to put that client's needs first. And so that could be where we are serving for a family, whether we're helping with someone who's disabled or elderly, and we may be helping them with their finances, but we can also help with medical care, decision making, things like that. So fiduciary is really just sort of a big umbrella term that covers trustee, executor, you may have heard the term conservator, a guardian, power of attorney for medical or finance. And also we do a lot of consulting and bill paying. So I have a lot of clients that maybe aren't ready for my services just yet as a trustee, because maybe they're still serving as the trustee of their own trust, but don't necessarily feel comfortable dealing with their finances anymore. So we can set up bill pay for them in the interim until they need more help. So those are just some of the different ways you may have heard of a fiduciary before with those other terms.
So you wear a lot of hats.
We do throughout the day. We change them multi times during the day, depending on the client.
Yeah, okay, great. And so, a lot of the times too, people ask, well, why hire a professional fiduciary? At what point should we even consider getting a professional fiduciary involved, whether it's related to legal documents specifically, or maybe in a more informal capacity?
Yeah, and that can come up in a lot of different ways, whether it's you're working with an attorney to update your estate planning documents, or maybe you have a neighbor or somebody who you notice is maybe having some problems financially, or you think someone's taking advantage of them. Or it just could be a lot of different ways that it comes up. But really what our job is that when there's a need for someone to be protected, whether it's their finances or whether it's helping them with caregivers or acting as a neutral third party. So those are some of the ways or just different scenarios where people will say, oh, I've never heard of a fiduciary, what do they do? And then they hear from their attorney or a financial advisor or someone else who says, I know someone who could assist with that and take the burden off the other family members or protect them if they're maybe potential they're predators and trying to unduly influence them to maybe give them all of their assets because they're now their caregiver, and maybe the family isn't able to take care of them, so this new person's come in. So it could be in a lot of different areas, but that would be why people would want to hire a fiduciary, because it would be a neutral third party, and that again, they have that fiduciary duty to put their clients' needs first.
Yeah, and we'll talk a little bit too in a little bit about some situations where that neutrality really comes in and is really key to making sure that everything runs smoothly. And so when it does come to estate planning documents, we're not going to go too much today into the nitty-gritty of what all the different documents are, but like Shannon mentioned earlier, and like you saw on the slides earlier, typically the times where you would be considering a professional fiduciary would be for like your revocable living trust, durable power of attorney for finances, advanced healthcare directive, and possibly also for your last will and testament. And so that would be kind of the general realm of formal estate planning documents where a fiduciary may be nominated, and maybe not even as the primary person that you want designated in those documents, but perhaps as a backup. But in any event, those are the documents that we're referring to. And so pretty commonly, right, it would be,
we find that when people are going through and working on these documents with their attorneys, some of these things start to come to the surface a little bit, and then they are referred to us to talk about what our services are. And that can be where sometimes families don't have children. I have a lot of couples that have no children in the area, or just they never had children. A lot of same-sex couples will contact me because they were thinking about maybe having their nieces and nephews help, or friends, and now they're finding that their friends are the same age they are, and they don't want to burden them, or we're wondering if they'll be there when they need them. And and also with everyone being so far away from each other now, and people taking jobs out of state and all these different places, then families are spread apart and they're not available there to potentially step in when there might be a need, a family member gets sick, that kind of thing. And the other thing is that sometimes there's conflicts in families, when there's maybe divorced or families where they're sort of blended families, or just all different types of family scenarios where there might be some conflicts that the family wants to avoid in the future, and so they name someone who's neutral, so that way it just sort of eases the tension for the rest of the family members. So it just really usually comes up, like Alyssa was saying, that when she's meeting with her clients to go over these different documents, or maybe update them or create them for the first time, people start thinking, oh, well, I was going to name so-and-so, or I have named so-and-so, but I'm thinking that might not be the best choice now. So it's good to look into the option of a fiduciary.
Yeah, and definitely I would say, in a lot of times when I'm meeting with clients and we're considering who to name as a trustee or an agent under powers of attorney, like Shannon said, they'll say, well, I have my siblings, they're about the same age as I am, or I have cousins, and I don't know if they're going to be capable of taking things on, and they may already be in their 80s or their 70s at that time. And so considering really, when you're doing estate planning, you're thinking long term, you're thinking what could happen potentially even 20, 30 years from now, depending on how old you are. And so the age of the fiduciary that you're picking, or the potential that they'll still be around and able to step in, is a really big consideration. As far as avoiding conflict, one of the items listed on there is if a client has a concern about their adult children handling money because of concerns about substance abuse, or they have a lot of creditors out there, they get in a lot of debt, or maybe have some gambling issues. And so, instead of putting their other adult child in charge of managing it for the child who maybe is not so good with money, and creating conflict between those children and potentially damaging that relationship, it can be really beneficial to consider a neutral third-party fiduciary like Shannon to step in, because she has no skin in the game. She's just following the instructions of the trust, and it can preserve the relationship between adult children as well as time goes on.
Yeah, and again, we have that duty, to follow the trust, and that it's like a contract that we have to follow. And so when we start going about doing the administration, we have to go through that and work with the attorney and make sure that we're doing it right. Because if we don't, there can be a lot of problems. And so our job is to try and follow those wishes as best as possible and then make sure that all the beneficiaries are taken care of. And it does take the burden off of the children and feeling that they have to do that, or helping ease any tensions that there might be.
Yeah, absolutely. Okay. So really the meat of what we wanted to talk about today, which I think a lot of people were curious about, was, just some tales from a professional fiduciary, and really situations where a fiduciary or a professional fiduciary may need to step in. And some of this is from, our own personal experience in cases that Shannon and I have dealt with together, whether it was, through me representing a beneficiary who needed her to step in and take the place of another trustee, or someone who was acting on behalf of the person who created the estate planning documents. And so, these are some of the kind of, I shouldn't say horror stories. I don't think horror stories is a good way to put it, but some pretty common situations where it may be most appropriate for a fiduciary to step in, even in a situation where maybe a fiduciary wasn't named already. And actually, a lot of these situations are ones where, as you'll see as we go through them, situations where someone else was already in place and then they were not the appropriate person to act as the trustee or executor. So,
yeah, and whoever you choose as your trustee or power of attorney, you just want to make sure that they are capable of doing it, because if not, then the court has to get involved, and it could delay things for the beneficiaries and things like that. So really this is sort of some stories of things that have gone wrong, but also things to keep in mind when you're choosing the right person, because then you could help avoid putting the wrong person in charge, whether you hire a fiduciary or not. I mean, lots of family members and friends could do the job as well. And so we're not saying absolutely have to hire a fiduciary. We're just saying, in our experience, this is what we've seen when people who've never done this before, or maybe did it once for their own mother or something, or father, they've done it and they think, oh, I can take it over. Every trust is different. Every family is different, and every setup is different. All the assets can be a bit different. So if you haven't done it before, or you have, but you had limited experience, there are a lot of pitfalls that you'd want to avoid. So we thought that we would talk about some of those pitfalls, and so that way, when you are deciding on the right person, that you can keep these in mind and sort of help weed out who might be the people that might not be the best for the job.
Yeah, absolutely. So the first one on our list is, the unorganized trustee or executor. And one of the examples that Shannon and I were talking about was, in this case, I was representing a beneficiary who, hadn't been given much information from the trustee. There was another person who was basically a family friend who had been put in to manage the trust. And it had been going on for many, many years. And due to how unorganized that trustee was, my client, the beneficiary, hadn't received accountings, hadn't received very basic information that they were frequently requesting of the trustee. And it really got to the point where, because that trustee was so unorganized and didn't keep records and kind of just handled it very carelessly, that we had to get someone else appointed. And in that case, Shannon was the one for the job. And we had to basically get that person to step down and be replaced by Shannon. And, Shannon can say kind of how she experienced how disorganized
it was pretty bad. It was an ongoing trust, and the trustee had been there for several years, and there were a lot of assets to manage for this particular beneficiary. And the beneficiary had been asking for, accountings and things that are pretty standard and had been written into the trust, hadn't been receiving them. And so as time went on and they got more and more frustrated, that's when they stepped in and got some help. Well, when everything was finally turned over to me, I saw exactly why accountings had not been provided as they were supposed to once a year, was because over all of those years, there were so many missing statements, bank statements, all different kinds of asset statements. So it was really hard to put together the picture of what had happened over all those years. and really get an idea of what was happening with the assets. So it was a really complex case to start with. And I think the person who took it over originally probably did it because they felt as though they wanted to help out the family. So again, somebody with good intentions who wanted to help, but just wasn't really up to the task with all of the necessary things that needed to be done. So unfortunately, there were no reportings done and accountings done. So everyone had been in the dark. So finally, we had to get it. There were boxes and boxes of statements that had to have been gone through. And we use accountants, but we also do have to go through all those with the accountants. But the poor accountants really struggled to get the job done, and I felt very bad for them. Luckily, though, we were able to get through everything and get things back on track, but it took a lot of time and a lot of money. So that was a really unnecessary expense, was because accountings typically are pretty easy to do as long as you're gathering the information throughout the year and keeping it well organized, and then giving it to the accountant to have prepared and then looking it over. Maybe a few hundred, dollars to get it all done. But this cost the trust thousands probably. So I would say that was a really expensive mistake, and it was someone who was trying their best probably, but just got beyond them. So the unorganized trustee is not a good trustee, unfortunately.
It can really result in some additional expense
exactly.
And I'm sure stress on the part of the trustee who, like Shannon said, she was trying her best, and she was even retired from what I recall. And so even for someone who is retired, it can be difficult to step in and manage multiple properties and keep really good records and stay organized because, as Shannon's mentioned before, there's ongoing duties and responsibilities. And so essentially for the duration of that trust, and as long as that trust was going to exist with that trustee acting, she had to be on top of it. And she, life gets in the way. And so, like Shannon said, an unorganized trustee can sometimes result in ineffective trust administration.
Very much so.
Yeah, and that can even happen in the context of a probate as well. But this is just an example of a trust administration.
And probates are a little bit scarier because you have the court wanting to get updates, and they can be a little punitive if it's not done properly. So you want to make sure that whoever you have listed as your executor, trustee, or unfortunately, sometimes the person who does the probate isn't really chosen ahead of time. So, being unorganized is, problem in life, but definitely a bigger problem when you're a trustee.
Yep, absolutely. All right. So another category of trustee where it may result in some issues is a trustee or an executor for a probate who is inexperienced.
Yeah, inexperienced. And I will attest to that when I first started doing this. I mean, there is a lot to learn. When you're a trustee, I mean, you do have to go through the trust and follow everything to a T. So you have to read through it, work with an attorney to help explain it to you if you don't understand what it means. And then there are just some things that have to be done by law when you're a trustee, such as notifications. If there's assets such as anything that's titled, a property or different accounts, those all have to be retitled. So you have to learn how to do all of that, meaning when it needs to be done and letting the attorneys know that there are assets that need to be retitled, such as a house. So, a property would have to have an affidavit, and that way, so that when they're sending out property taxes, if they don't know who the new owner is, those property taxes are not going to go to the proper person, and they could be late, which would result in fines. And so not understanding these different things, and then also just how to relate to the beneficiaries. I mean, they're going to be very eager to learn about what they may be getting in the trust, and a lot of questions. And also there's a lot to do with confidentiality. You can't speak to anyone about the trust who isn't a beneficiary. And so you just need to be really careful when you're managing a trust, that there's a lot of things that you just need to know about. And then filing taxes. We file taxes for the final taxes for the estate and or the deceased person. So it's just knowing that you need to do those things. And with the help of an attorney, that's great. They'll walk you through it, but not everyone probably listens to what they're supposed to be doing, gets into trouble.
That never happens.
Making distributions too soon, running
Mhm.
out of money, can't pay the final taxes,
Mhm.
not withholding a reserve. I mean, these are all pitfalls for someone who's never done it before.
Mhm.
And if they aren't listening to their attorney, then they can fall into some trouble.
Yeah, and I think a common situation that I've run into, not with my clients, because my clients are always angels, but no, but from the perspective of sometimes beneficiaries, or just when I get a new trust where I've heard that things haven't been going very smoothly, if there was an inexperienced trustee who was managing the trust, um, you know, we don't expect trustees to know everything right from the get-go. That's why it is recommended to meet with an attorney to get at least a checklist of items that they should be aware of. And like Shannon mentioned, there's deadlines, there's specific documents that need to be completed within a certain amount of time. Otherwise, you could risk fines or losing out on possible benefits to the trust or to the estate. But they're pretty commonly, too, I would say, there's sometimes our trustees who because they have never dealt with something like this before, they don't realize how formal you have to be and how very specific the full administration of either a trust or a probate has to be. I think one of the most common situations that I hear of is a trustee who maybe had a discussion with the decedent, the person who created the trust or who created the will, had a discussion with them a few weeks or months before their passing, where that person said, well, I'd really like it if you could give some money to this person. But they never actually updated the documents, nothing was formalized. And that trustee, probably trying to honor the wishes of the person, I find out later that they have already gifted $10,000 or $20,000 or even, $100,000 to someone who's not even listed in the documents as a beneficiary. And so, that's always
so bad.
That's always a tough conversation to have.
Yeah, that's not a good one. So
Yeah.
we want to avoid that.
Yeah.
So, inexperience can be risky and costly to the trust and the beneficiaries because once the funds are gone or spent or just mismanaged, if they're not a fiduciary, because fiduciaries we have to carry insurance, that money could be gone for good. So it's just really important to again avoid some of these pitfalls.
Yep, absolutely. All right, another category of issues could be if the current trustee or executor is stagnant or slow. It's like the tortoise trustee.
Right.
Right.
Yeah. I mean, trusts usually take about a year generally to close. It could be that it takes a little while to find all of the assets, to sell them all, and then to distribute and to pay bills and things like that. But there are times where things do take a little bit longer. But generally speaking, it should be about a year to a year and a half, right?
Start to finish.
Start to finish. Yeah. So that's about how long. And I always try and make sure that I let the beneficiaries I'm working with know that it will be a little while until we can get some sort of estimate to what their distribution is going to be. And then once things sell and all of that. But there is an expectation that things will happen quickly. And so I do try to set the proper expectations. But there are times where some trustees have not maybe, I don't know if it was just they didn't want to move things along or they just felt stagnated by things or overwhelmed. But there have been some cases that we know about where the beneficiaries really, or the trustees really dropped the ball and the trust just drug out for years.
Years and years.
Yeah. And I think this one particular case I'm thinking about was a lot of the beneficiaries were not related completely, like maybe friends and things. So they were all spread out. So they were just getting trickled information sent to them about things. And I think they didn't really understand the process. And so it was just drawn out probably much longer than most people had sort of anticipated.
Yeah. And there's always, the risk too, where if not everyone's on the same page or it's not a relatively really straightforward trust administration, there's another case in particular that I'm thinking of that Shannon and I dealt with where it had gone on for so long that people who were entitled to receive assets from the trust had passed away.
Oh, yeah.
And
Right.
not only they had passed away, but the people who could have inherited from them also passed away.
Yeah.
And so, we were dealing with a situation where it was not just a trust administration, but because it had been going on so long, we had to go to court to actually clarify what all the beneficiaries' interests were. And even after that, it was a little bit tough in trying to make sure that everybody appropriately got what they were supposed to be receiving.
Yeah, and that was the worst part too, I think, because of all the delays and time, and then having to have another fiduciary step in and then kind of get caught up to speed as to what had been happening and what had gone wrong, and then the court fees. Again, you're talking about extra expenses to the trust that shouldn't have been there, and people should have been paid a lot sooner. So that money was just sitting there earning probably very little to no interest over all those years. I mean, we're talking several years.
Yes.
So yeah, and then we came across the problem with people having been deceased. So that added an extra wrinkle. So getting things done in a timely manner are really important with these trusts.
Yeah, and of course it's always going to be dependent on the trust instructions, but in this particular case, because certain interests had already what we call vested at the time that the person who created the trust had passed away, the delay really did result in additional costs to the trust, so that we had to actually clarify where everything was supposed to go. So
it took just a lot of time. I know, and things can too. I mean, if there's maybe court action and things like that, that's understandable. But someone just not getting the job done, that's not really.
Yeah, absolutely. And then another category would be if the current trustee or executor does not get along with the beneficiaries, or in some cases where there's maybe only one beneficiary. And the case in particular that I'm thinking of, and I'm sure you're thinking of as well, is a case where there was only one beneficiary, a situation where it was a friend who was appointed as the trustee, and that trustee and the beneficiary did not like each other. They had, for many years, had a very, very angry relationship, to the point where the trustee, really wasn't doing what they were supposed to be doing, because there was some resentment and they didn't really want to give the beneficiary anything, and they had different concerns about people other than the beneficiary. And so, that resulted in a very long, drawn-out negotiation to get someone else involved. And in that case, again, we were able to get Shannon involved so that she could be that neutral person to smooth things out and purely just follow the instructions of the trust for the benefit of the beneficiary without any personal agenda or bad feelings.
Yeah, and personal agendas, that's a really great way to describe it, because you do have those trust instructions that you're supposed to follow, but no one's really watching other than the beneficiaries. And so if things aren't going right, I mean, they have to speak up, maybe hire an attorney. So this is the big reason really why you want to make sure that you have the right person, because if the wrong person is in there and the beneficiaries want them to be removed, they actually have to spend their own money to hire an attorney to try and have them removed. And then the trustee can use the trust funds to, unless they've done something wrong, illegal. But if it's just a matter of not liking them or saying that they've done things that they shouldn't have, and it still has to be determined, that trustee can use the trust funds to find representation. So again, it's wasting money that should have gone to the beneficiaries by choosing the wrong person, and having someone who is not going to have that beneficiary's best interests in mind, not having a fiduciary duty to that beneficiary, could be really detrimental to that beneficiary, especially if they don't have the funds to find someone to represent them to get that person removed. And you can't always, it's not always guaranteed that you can actually have that person removed. You have to have some good reasons for it, rather than we just don't like them. So it's really tough once they're there, and to have them removed, unless there's a clause or something in there that gives those beneficiaries a little bit more power, or maybe a trust protector or something like that, you're really just at the mercy of that trustee. So you need to make sure you choose the right one.
Absolutely. A little less frequently, but something that does come up too is the next category, which is a trustee or an executor who abuses their power. The case in particular that I'm thinking of is another one that ended up having to go to court. And we found out through reviewing records and finally extracting information from the trustee that a lot of money had gone out to fund that trustee's travel, vacations, and other beneficiaries weren't receiving any assets. The trustee was abusing their power and engaging in conflicts of interest that only benefited themselves to the detriment of the rest of the beneficiaries. And as Shannon mentioned before, because that was a in this particular case, it was a non-professional fiduciary, and so all of that money was gone. And we had to go to court and clarify again what all of the interests were, because the overall interest that everyone was supposed to receive was actually significantly reduced by what that trustee had paid to themselves. And at that point, we had to decide, or you have to make a determination of whether it's worth it to go after that trustee or that farmer trustee who is not collectible because they didn't have insurance, and they're not required to have insurance when acting as a trustee. And so, everyone's shares got reduced in that situation.
That was really sad for the other beneficiaries, and I'm sure it put a huge wedge between them. They were family members, and you'll never recover really after that, probably, and the distrust that was there. And it was, a family member that had been put in charge because the parent thought that they were the best person. And maybe they, did do, things at first that were trying to be a good trustee. But I think sometimes there's a lot of money in these estates, and I think it can create some bad behavior.
A little temptation.
A little bit too much temptation when they have this account with so much money in it that only they have access to, and not sharing that information to the other beneficiaries about how much is in the estate, not providing accountings, not giving information, and then just using it as their own personal bank account, and then it being gone because once it was spent, it was spent. And so that was really sad.
Right, yeah. And really, they don't really face any repercussions at that point unless they are gone after. But, sometimes you have to make a calculation also. How much is it going to cost to go after them?
Right. And do you want to file criminal charges? I mean,
it's
family
a
members
whole,
don't want to do that. Really, it's just, So just avoid that if you can.
And these, again, are more like horror stories, right? It's very few and far between, but some situations where a fiduciary was definitely the most appropriate to step into that.
Someone trustworthy for sure.
Absolutely, yes. And then the last category that we wanted to go over was if there's no trustee or executor available. And this is pretty common.
It does happen with when they've made some choices of who will be there, but those people then are unavailable, can't do it, won't do it for whatever reason, and now there's no one.
Yeah, and so, depending on what the trust provides for in that situation, each trust is unique, so there might be a method put into the trust for another trustee to be appointed in lieu of the person who's unavailable any longer. But if there's no language in there, then usually what ends up happening is the beneficiaries or someone else interested in the trust has to go to court and ask to be appointed to represent the estate or to represent the trust. And in that case, a fiduciary can be really helpful, especially if a beneficiary is, for example, a special needs beneficiary, and maybe they themselves are unable or inappropriate, or you wouldn't want to disqualify them for public benefits by getting them put in charge as a trustee or someone in charge of the trust. And so, there's some situations like that may come up where a fiduciary is going to be the best option to step in. It will require court action, which, as you probably have heard in a lot of my previous presentations, is our primary goal is to avoid court action if we possibly can with all of these legal documents and estate planning documents. But sometimes life happens, and if that person is unavailable who you have appointed, or even if you had a whole list of people that you wanted to appoint and none of them were available for whatever reason, or unwilling to step in, right, for any reason, then it can be a good situation for a fiduciary to step in. And Shannon and I are working on a case right now that's multi-layered.
Oh yes.
But
so many facets.
There was, in this particular case, which is almost like a very multi-case connection, but no one was either appropriate or available in these multiple matters to step in. And so at the risk of having beneficiaries fight over who would be the appropriate person to step in, she was the best person. And she's doing a great job so far. So
I'm working on it. But yeah, I mean, that's really hard. So I'd say that, making sure that when you're working with your attorney that you are going over them, maybe every 5 or so years, and having them looked at again, just to make sure that they're still set up right, that you have the right people in place, that people that you've chosen, sometimes people forget, who they've listed. They may remember the first person, but typically people list about 3 people, first, second, and third position as a successor trustee. And it's always good to revisit those and look over your documents and update them, so that way you don't run into that problem of not having anyone there. So it's really important to keep those things in mind.
Yeah, absolutely. And sometimes, the pitfall is not so much that anybody's not getting along or that there's some big conflict that's happening at the time. But if there is no trustee or executor that's available or willing to step in at the time, then everything is at a standstill until someone can get appointed. And so there's also that kind of added factor or added consideration of the practicality of that happening, and whether bills go unpaid or property taxes go unpaid during that time. And it can be risky to the trust, which, at the end of the day is not really the fault of anyone in particular, right? It's just sometimes that comes up. And so in that case of fiduciary, because they are very aware of what all of the rights, responsibilities, duties are related to these documents, are generally very efficient and know exactly what needs to be done to get everything back on track. So yeah, that pretty much covers most of the tales of
quite a few different scenarios.
Lots of scenarios.
There are so many out there. With every single trust and family, there's a different scenario. So it's just learning how to navigate them and setting them up right in the first place is probably the best policy. So
yeah, absolutely. And so, you've seen some situations where, maybe the person who was appointed is not the most appropriate person. And so we're kind of giving you some warnings about, what to look for. And you probably know these people best if you're appointing them or want them to step in. And so, yeah, just, consider what their, typical way of handling things are. Whether you think that it would be easy for them or difficult for them to basically step in and manage your whole financial life, whether it's during your lifetime or after your death. And that's really important to consider. And again, fiduciaries are a really good alternative to family members, or if you can't think of anyone in particular who would be appropriate to step in. So, so that pretty much covers everything that we wanted to talk about today. We did want to open up the floor for any Q&A or any questions that anyone logged on might have. Let's see.
Are we able to see the questions that come up?
Or have any?
Has any?
No questions?
Oh, wow.
Oh, okay.
Well, fantastic.
Well, you've got our contact information right there. If you have any questions or concerns, or if you run into an issue where you think that maybe, a fiduciary may be appropriate, then feel free to reach out. I think, did maybe one question pop up? No? Yeah. Oh, yeah? Oh, okay. All right. So hang tight real quick. We'll get the question up in just a second. So the question was, I'm assuming for this person's own estate planning documents, can they appoint the beneficiary to also act as the trustee. And that's pretty common. I do often have clients, for example, who maybe have 1 or 2 adult children, and they end up leaving everything equally to that child or to those children, and then choose either that one of the children or both children to act as trustees together. So yeah, there's no issue with naming a trustee who's also a beneficiary. There's just the potential issues that may come up later, where maybe there's multiple beneficiaries and that one trustee maybe unwittingly doesn't treat all of the beneficiaries equally. So.
Right. Or it could drive a wedge between the 2 remaining beneficiaries if one doesn't like how the other one is handling it. So,
yeah.
But yeah, I mean, naming your children, I mean, I'm sure is usually the first choice because you want them to take over and to do it. So yeah, it's just when they can't or aren't the best choice.
Yeah, absolutely. Okay.
Next question.
Oh, okay. So the next one is who monitors the work of the fiduciary, and who monitors the fiduciary when there's no beneficiary left? Ooh, that's interesting.
That's a great question. So we do have the Professional Fiduciaries Bureau who does the licensing for us, and we have to do a yearly renewal of our license. So if there are any complaints about us, that they would hear those and then decide based on whatever happened if that we could be renewed. But really, whoever is the beneficiary could potentially speak out about anything that we're doing that maybe isn't right. And the recourse then obviously is they could have us removed. But what happens if there's no beneficiary? Well, usually there is a beneficiary. Someone is going to get the money, whether it's the if they're sending it to a charity or someplace like that. So when we're done administering a trust, we have to prepare a full accounting, and that shows all of the assets that came under our management, and then anything bills that we paid out, even our own wages for the work we've done. And then that all goes out to all of the beneficiaries, and they get to review that. And I think they have 120 days to make any complaints. What is it?
180.
180.
Close, real close, yeah.
So a little bit longer, 180 days to make a complaint or to inquire more information about the accounting. So there are checks and balances for us, definitely.
Yeah, and it's pretty unusual that there's no beneficiary that's left under the trust. Most estate planning documents will either have some contingency language of, well, if none of the primary beneficiaries are alive, should the portion go to their children? Or if there's no children, there may even be another, I often call it a doomsday scenario beneficiary, where if none of the primary or first or even second level beneficiaries are alive or happen to pass away at the same time as the person who created the trust, then there typically will be a backup. And worst case scenario, it can go to the state if there is no closest living heir at law or someone who's identifiable as a potential taker of what is left in the trust. Okay, so next question is, Alyssa, are you able to review a living trust? And the answer is yes, absolutely.
Recommend it.
Yeah, recommend it. It's good to double check. I know a lot of times too, clients, or not even current clients, but people who I meet with will ask, how often should I meet with my attorney, or how often should I get things looked at? And, like Shannon said, every 5 years or so, that's a pretty good metric. Or if things change, if your circumstances change, then it's a good idea. I have had some clients come in and they say, oh, we haven't looked at our trust since 1990. And I think, oh, that's the year I was born, and you haven't looked at it yet. But you know what? That's okay. Better late than never. So
definitely.
So yes, long-winded answer, yes, I can review a living trust. All right. The next question is, I have a special needs daughter. Who would I get to handle funds for her? And that's a really good question. And so there's a whole type of trust called, it's not, a technical type of trust, but we do create trusts that are known as special needs trusts or supplemental needs trusts. And that has to be done in a very specific way. I don't want to get too far into the weeds about the different types of special needs trusts, But essentially, if you do work with an attorney to establish a special needs trust for a child or a beneficiary who is on public benefits and probably will never be able to work, or their disability prevents them from being able to have income in the future, then you want them to be able to inherit some assets without getting them disqualified for SSI or Medi-Cal. And I won't get too much into the rules about eligibility for either of those benefits either. But in that case, you know, the trust in that situation will probably last, and the intent usually is that it will last for the rest of your child's lifetime. And so in that case, I almost always recommend a professional fiduciary to act as a trustee, because the trustee needs to know exactly what type of disbursements are allowed and that are not allowed in order to preserve that beneficiary's public benefits. And also, depending on how the trust is set up, whether the trustee is even allowed to make certain types of disbursements.
Yeah.
And so Shannon's been a special needs
tricky.
trustee in a few situations, or quite a few situations.
Yeah, it is pretty tricky with special needs trusts. So some family members will name, you know, other siblings to do it, or other people, and that's fine too. But it's just, it is tricky. So you would want to make sure that you name someone who would have the ability to understand all and learn all of the rules, so that they don't make distributions that would jeopardize the benefits that beneficiary is getting. So yeah, but I mean, anyone can serve as a trustee for special needs trust. It's just, you want to make sure it's somebody who would understand all those rules.
Right, absolutely. And you know, sometimes too, if you do choose a child, one of your other children or another family member to act as a trustee for that special needs trust, they can also always consult with someone like Shannon to see, you know, get some advice, get some guidance on what they should be doing. And if it becomes too much and they, you know, decide that it's a little difficult to manage all on their own, then most trusts will have some mechanism for getting a fiduciary involved at a later date.
Yeah.
Oh, okay. So I don't know if the question...
Probably for me, but you can. So we bill at an hourly rate. So right now the range is, for most fiduciaries in the Sacramento area, is about 120 to 150 an hour. But we do bill incrementally, just like attorneys, 0.1, 0.2 of an hour for things that we do. And so it doesn't matter the size of the state. We will just bill for our hourly rate for what we do. And that's all, like I said, usually provided to the beneficiaries after we're done doing our administration.
All the information about time spent. Yeah,
exactly.
And I think a lot of times too, people want to know, when does that billing start for fiduciaries?
Yeah, good question. So it really doesn't start until we actually start doing the work. So even if you name us in your documents, we haven't really done anything for you yet. In fact, we don't even have authority to do anything for you yet, even though we're named. So it really just is, we're there until you need us. And then once we are called and we do start working under the authority of those documents that you've named us in, then we would start billing for our time.
Yeah.
Good questions.
Okay.
All right.
Well, that concludes today's presentation. Thank you, everyone, for joining us today. Thank you, Shannon, for being our special guest today.
Thanks for having me. It's so fun.
And if anybody has any other questions, again, you have our information, so feel free to reach out to either myself or to Shannon. And I'm sure you'll see us back here for future presentations.
More fun.
Yeah. All right. Have a good evening, everyone.
Bye.